Hi guys. So I wanted to just put together something brief using all the information from Inner City Press's tweets. I have seen, I've only seen one other creator's video, and that is Teresa Concepcion. So I'll give credit as well to her. So just kind of formulating my own thoughts really on what happened in the hearing yesterday. I obviously wasn't there, but I wanted to look at everything and just give a few thoughts on what happened. So basically, obviously, Lively went first. They had a half an hour each side. And basically, what Lively's team sort of started out with was that the Wayfarer parties sued Lively, and the court dismissed that lawsuit. And they provided privilege under Section 47, which was the litigation privilege and the fair report privilege, which I talked about yesterday in my pre-hearing video. Lyman, by the sounds of it, then said, "You're asking the court for relief. Ordinarily, you bear the burden. Do you have anything that would apply 47.1 to a fee application or for damages?" And Gottlieb was sort of responding with, "This is a new statutory provision, but treble damages are mandatory." Lyman was basically saying, look, the First Amendment applies to both sides. It's the same amendment, no? And Gottlieb said that California can make the tort of defamation available to some. Lyman then said the compensatory damages could far exceed the attorney's fees. And Gottlieb said, well, it's similar to other anti-SLAPP statutes, like the Nevada statute, the SDNY and Second Circuit interpreted in the Adelson case. Now, Lyman makes the point that, well, in his order dismissing Wayfarer's complaint, that with respect to Lively, he didn't actually he didn't give any opinion on malice, and whether, there was no evidence that she hadn't acted with malice. He just said nothing at all. He did with Ryan Reynolds, with the New York Times, and with Leslie Sloan, but he did not reference anything about malice with Lively. And then Gottlieb sort of said, in California, the prevailing party is entitled to these damages. It is their burden to show it was without malice. And when he says it's their burden, I'm sure he's referring to Wayfarer. The thing is obviously malice is a triable fact, and we have not had a trial. So I have an issue with that myself. I think Lyman, by the sounds of it, was having an issue with it. I'm sure many content creators have had an issue with it too. Let's have a look. Gottlieb made the argument that the statute was decided to protect a certain class. Our argument would be that the same burden shifting framework would apply. Judge Lyman pointed out that, well, what if about dismissal on 12B2 grounds. And that would be a problem actually for Lively, because if Lively conceded that a 12B2 dismissal does not entitle her to relief, then that is going to impact her case in Texas against Wallace, where the case was dismissed on 12B2. So let's go back. Oh, here we are. Right. So Gottlieb then argues that, well, we believe we have carried out our burden and are eligible for punitive damages. All that remains is the calculation of damages. And again, what burden? They just settled the claims. What wasn't dismissed, i.e., only 3 out of 13, 15 if you include the 2 intentional infliction of emotional damage claims that she voluntarily dismissed herself back last year. But we had 3 claims still pending, and she voluntarily withdrew them when she settled. So I'm really struggling with trying to understand what Gottlieb means when he says we believe we have carried our burden. Lyman then asked, how do you square that with Rule 54? And Gottlieb made the most bizarre comment that he says that Wayfarer had waived that. Like, when? I have seen nothing where Wayfarer have waived Rule 54. I've seen nothing at all. Gottlieb then says that he asked for this in our motion to dismiss. What that is, I'm not quite sure, because obviously Inner City Press can't get word for word. So they are, Matthew's doing his best. So it may be a bit kind of clunky here. Lyman is saying, okay, without any jury trial, would that comply with the 7th Amendment? And Gottlieb says, well, that hasn't been raised here, and I'd like to reserve the balance of my time. Ellen then comes in and says, Gottlieb seems to be arguing that 47.1 applies regardless of the grounds of dismissal. Lyman says, well, can't the California legislature do this? Ellen says the only decision on this has been Evans v. Walker on March 4th. Lyman says, aren't you arguing that if a complaint were frivolous on many grounds, 47.1 wouldn't apply? But if it were frivolous on only one ground, 47.1 would apply? And Ellen says, no, there is also the claim of damages. 47.1 is an unusual statute. It's fee shifting. She then says, Gottlieb argues that some anti-SLAPP statutes also provide for damages, not only fees, but those statutes provide for the presentation of evidence, even a separate lawsuit. That's not the case here. And the judge points out we've settled everything else. I think what Ellen was saying is basically that in anti-SLAPP statutes which apply to damages and not just fees, there are entire lawsuits, or at least evidentiary hearings. But that is not the case here. So there are, the experts they've done their reports, they've had their depositions, but it's not really enough. And again, the damages also would have been a fact issue, which would have been decided by the jury. And then when we talk about damages, again, there are 2 things that bother me greatly here. And again, if I go to the bar chart, there's a big issue when it comes to damage, because it's only really the reputational damage really is what leads to everything else. And Blake Lively was very much talking about her reputational damage. And the top 3 instances of negative online sentiment were her promoting the film, which was abysmal, her CRD complaint in the New York Times and the publication of the New York Times article, and then her amending her own New York complaint. Those are the only 3 above this orange line. Everything else is way down. And if you look at the point where Wayfarer actually filed their complaint that Lively is trying to claim all these damages for, is the red bar which has the little green dash above it. If you look at where it is above, not below, because um, the dash is marked below in line with the date that correlates. But if you look above the bar, where I've dashed it with a little green highlighter dash, it is a very small red bar compared to other red bars. It's not insignificant, but it is tiny compared to, if you look at the largest bar, is actually the New York Times article with the pink dash above it. So, and the amendment of Wayfarer's complaint is irrelevant. That was a higher bar, but it is also irrelevant because she's claiming these damages for the filing of the complaint. And I know they keep trying to sew in, Friedman's statements. Well, Friedman's statements are not attached to the complaint. They are in response to the New York Times article and Lively's complaint. They're not actually linked to Wayfarer's filing of their complaint. So I don't think they are relevant. But also, and I mean, Teresa said that Ellen made this point, and I think it's an absolutely stunning point to make, is the entire duration of this lawsuit, including actually at the point the New York Times was filed, Lively has talked about her being damaged by the smear campaign. At no point has she said that she has been damaged by Wayfarer's complaint, but by the actual smear campaign, which is not the complaint. She cannot say that filing a lawsuit is a smear. I'm sure she'll try, but she can't say that it is, that filing a lawsuit is a part of a smear campaign. That is absolutely ridiculous. And there is, a right to file in court, to come to court and file a complaint. So if I just, yeah, here we are, constitutional rights. Filing a lawsuit is a constitutionally protected right of petition. Penalising that act under Section 47.1 raises First Amendment concerns regarding access to courts. So I've already covered it in this slideshow. I will put a link to the video where I went through this PowerPoint presentation I put together. But by clipping someone's wings so that they can't even come to a court and bring a lawsuit that they believe, is they believe they have a cause of action, whether it gets thrown out for failure to state a claim or whether it gets thrown out for lack of personal jurisdiction, etc., whatever grounds it's dismissed on, people, it's generally accepted, and you would want this as well, but it is generally accepted that people have the right to bring a claim to a court. You have quite literally a constitutionally protected right. And one of the things that made me deeply uncomfortable about this Section 47.1 was that literally, if you bring a case for defamation against someone who is making, say, for instance, in this case particularly, making false public allegations that you are a sexual predator, that you have sexually harassed them in the workplace, you lose a right to defend yourself, but you also basically are deterred from a constitutionally protected right of petition. And I don't like that. Like, I yes, there definitely needs to be balance. There needs to be more resources for men and women who experience sexual harassment in the workplace. Absolutely. But you just know that where you stop someone from basically defending themselves, there is going to be an abuse of this process, as there always is. And we are seeing this play out in real time, because Section 47.1 is currently in not one, but two courts by the same person who made false allegations. And that's just in one court. In the other court, the guy was nowhere near her. And yet, we have a judge sitting with a fully briefed fee motion for Section 47.1 damages. I cannot make that make sense. I don't think I ever will. And if she gets that award against Jed Wallace, of all people, who's been, has not been anywhere near her and has never sexually harassed her, even by her own admission, he's never sexually harassed her, then I think the American justice system really needs a good shake-up, because that is wrong. And that is not what this law was meant for. And that's the infuriating bit, is you can see the good that was intended, but to witness it playing out in real time, by the person, by someone like Blake Lively, it just, it is everything that is wrong with the world for me. But that's just me getting on my soapbox. Okay. What else do we have? Yeah, so that was a great argument as well by just to circle back again. The argument from Ellen that, up until now, Lively has never ever used the complaint to say that she's never alleged that she has actually been damaged by Wayfarer's complaint. It has always been this non-existent smear campaign that innocent people were pulled into as well, including myself. And when that hasn't panned out, well, how does this sit? Because had she alleged that the complaint had actually done her some harm along the way, then that's a whole different thing. But she has never made that argument. Lyman asked, could they apply for this in California? When I saw that, my first thought was, dear God, no, I can't do this again. Ellen says that might happen. Judge then says, I'm pushing you because I have to construe this statute. And Ellen says, well, there's no court that gives us guidance on Section 47.1. And Judge says, well, that's why you're here, that's a fair point. And obviously that is why Judge Lyman is going to take his time with it. I'm sure he does not want to have this sitting in front of him, but it is sitting in front of him. So therefore he can't just, say, Lively, I don't believe you. That's that. He's got to make a reasoned argument on this, because what he says is about to become precedent. He's in a really difficult position. I do actually feel a little bit for Lyman at this point. So we continue. So Gottlieb tried to make the argument that Section 47.1 was trying to address holes in 47, where sexual harassment plaintiffs were targeted. Again, yes, I can see that, and I made this point yesterday in my video, right? Had Lively just merely said, to her agent at WME, right, Justin Baldoni sexually harassed me, and then WME dropped Justin Baldoni, right, then, in that context, that statement would not be privileged by anything in 47. There would be no litigation privilege because it's not wrapped up in any legal filing. It is also not going to have fair report privilege because it is not, as part of a news article, so to speak. So, and I think that's the whole that 47.1 was intended, was where an ordinary person says to another ordinary person, this person sexually harassed me. It was not intended to kind of add, I don't think, anyway, my interpretation is it wasn't intended to add more to where litigation privilege or fair report privilege already applied, which both did already in this case. So, and that was in itself deliberate. If we look at the sequence of events, you know, including Van Zan, right, and you know the um, kind of fraudulent use of the court almost in you know the using a sham lawsuit to get subpoena power to get hold of the contents of a private phone, and then that was literally the catalyst for you know what went into the New York Times. The CRD was an afterthought because it was literally filed, you know, the day before. But for the purposes of the New York Times, the subpoena would have covered them. But the fact that the text messages went into the New York Times already provided fair report privilege. The CRD was just like an extra step that Ezra Hudson took to wrap it up in litigation privilege too. So I think Gottlieb is kind of wrong to say that 47 point, well, I think he's half right in saying that yes, 47.1, its objective was to address a hole in 47, right? Where someone made an allegation or communicated that they had been sexually harassed in the workplace. And if they did that in an environment where the litigation privilege couldn't apply or the fair report privilege couldn't apply, then yes, 47.1 does a great job of protecting that person from kind of retaliatory legal action. But that is not the situation in Lively's case. Lively's case is very different. What else? I mean, I think the judge kind of said as well that you know, Lively could have just continued. We would have been at court already, probably coming to the end of it, and it could have, all the triable issues such as malice, damage, etc., would have been dealt with, you know, during that time. But she chose not to. She withdrew her claims and settled for literally nothing. Gottlieb says that they have to show that Lively's CRD complaint was made with malice. Again, no, it's not the CRD complaint. It is the New York Times article, which she was part of. If they had put in, a judge had done, if they had put in evidence that raised a triable issue, what would the next stage be? Gottlieb 47.1 speaker proof. You could take affidavits, but here they made no effort to meet their burden. I mean, he's just very much like, well, we could use what's there, the affidavits, the depositions, you know, so on and so forth. I'm not so convinced by that. Gottlieb also believes that they have met the test for punitive damages. And then he goes back to statements by Friedman. Again, they're not in the complaint. They're not in the complaint for defamation. And how do we know that they definitely relate to defamation? Could they not? I'm pretty sure they were quite specific to Lively's sexual harassment causes of action more than Wayfarer's defamation cause of action. And then judge said, well, is your client damaged? And the judge questioned, well, how are we going to get to damages? Harm to reputation, loss of jobs, all without a jury? Is this permitted by the US Constitution? Gottlieb says yes. The judge points out that there are separate anti-SLAPP lawsuits with due process protections. Why not think of it that way? Gottlieb says that 47.1 joins fees and damages. Gottlieb does make one small point in that, you know, he says that Wayfarer asked the court, this court in New York, to apply substantive California law. Now it has to apply 47.1, which it did. They did. They asked for California law to apply. And the judge says, I'm going to take this under advisement. Then Ellen comes in and says, well, one more point on the 7th Amendment. This is an end run around the trial that was eliminated by the settlement. And she also points out that they had Daubert motions scheduled. They have to be reopened, you know, in the event that this sort of continues, and they need to have some kind of evidentiary hearing on damages. And I think that is pretty much the kind of the summary of the entire hearing. That from the information that I have seen, that I'm sure there's probably more that other content creators, especially the ones who are there in person, will have access to. But I like some of the responses from, especially from Ellen. They were golden. The argument that, you know, that Lively has not until this point has never claimed any damage from Wayfarer's complaint is a big argument, really good one. The argument on the 7th Amendment was a good argument. The fact that the judge did have Lively dancing around concession, that dismissal by 12b2 would not have afforded her any rights to damages, was interesting, because obviously she's got a 12b6 in New York and a 12b2 in Texas. So, and you know, and Section 47.1 fee motions sitting in both courts. So, I can imagine the mental agility that it took to avoid saying something in New York that would not have been impacted the motion in Texas. Pointing out that, you know, malice and damages in particular are tribal issues of fact, and now we don't have a trial, which was, you know, due to Lively's choice. We would have been probably in the middle, heading towards the end of a trial, had she not settled when she did, was a good point too. The one point I have to give to Gottlieb, which makes me nauseous to do so, is that he did point out that, you know, technically Wayfarer asked for a substantive California law to be applied to their complaint. And, you know, with that, Section 47.1 is substantive California law. Where I have an issue with this, again, is, you know, it conflicts with Section 47 protections that are already there, and in this case, have already been applied. And I have a big problem with, you know, the cutting off someone's constitutional right of petition, their constitutionally protected right of petition, the right to bring a complaint to a court. Technically, Section 47.1 does actually stop that, because Wayfarer did not get far at all. They didn't really get into much discovery. A lot of the discovery in their complaint would have been a crossover for Lively's complaint anyway. So, I mean, really, what was done here? Now, do I think the key thing here is, from Wayfarer's perspective, is that they so that they could tell their side of the story? Yes, I do. Particularly cared that the complaint got dismissed. I think they just wanted people to read their side of the story and to see their evidence, because Lively was already shutting down. Like, they put a website where they were going to put all the evidence for everyone to see, make everything easily accessible, and it literally had one filing before Lively lost her ever-loving mind and went to the court and asked for sanctions. So I think that was the whole purpose that drove Wayfarer to sue Lively. I think if Wayfarer can minimize any impact to just attorneys' fees and costs, I think they'll see that as a win. But that is where I will not agree with them, unfortunately. I don't think there should be any damages at all. I could see Lyman splitting the baby and saying, okay, well, you can have attorney's fees then. It will literally be for the defamation cause of action, and the filing of the motion to dismiss. That's it. And these Section 47.1 fee motions. It won't be for any other cause of action. It won't be for any other party, because don't forget there was multiple defendants. There was consolidated actions. But it would be just for the motion to dismiss the defamation cause of action against Lively only, and the recovery of the fees. But I don't even want Lively to have that, and the reason is because then she will effectively be able to spin the argument that she prevailed on Section 47.1 fees, remedies, which are reserved for people who have experienced or complained about sexual harassment. And you can just imagine how the headlines are going to go with that. And I think it could do damage to Wayfarer. So I still think, I don't know, I still think that they should have gone to trial. I don't know, it's really hard, because they still would have had to deal with Section 47.1 fees. The annoying thing is had they just left the defamation out, there would be nothing they could do to bring Section 47.1. If they just run with false light, Section 47.1 is not a thing. Yeah, I don't know. I've still got a lot to think about, I guess, with it. But that's kind of where I am. Whatever the decision is going to be huge. It's going to be landmark, especially if something is awarded in Lively's favour. It will now become a landmark case. I'm always going to be infuriated by the circumstances that Section 47.1 is sitting in two different courts against different defendants, or different plaintiffs, sorry, which in neither case the circumstances support it at all. And the one thing, again, I will say I totally don't agree with Gottlieb is, well, I have agree with him in that I do think the objective of Section 47.1 is that it would have served as, served as something that would have benefited sexual harassment victims had they spoken out about their experiences to another person. I just don't think it was necessary here because, again, the Section 47 protections of litigation privilege and fair report privilege had already been applied. There's nothing more Lively wants, but she is just looking for the win. I don't even think she's wanting the money. I just think she wants the win for the headlines. And that really pisses me off, because that's just not what this is meant for. It's such an abuse of a resource for people who have truly suffered, and Blake Lively hasn't suffered shit, to be honest. Okay, so that's my little thought process. Feel free to obviously ask questions in the comments. I will catch up with comments today, actually. I'm falling behind again. Sorry about that. I am going to, given that Lively Wayfarer is now wrapping up and there isn't just not much happening with other lawsuits at the moment, I will be looking at, oh God, I can't remember. There's one with an author, I think, I've been asked to look at, where one of Gottlieb's colleagues is part of that. I've been asked to look at that, so I'm going to take a look at that. There's a fee motion from Friedman and his firm against the estate of Travis Flores, which I need to do tomorrow. And there was a hearing yesterday in the Celeste Smith against Wayfarer Foundation and Steve Sarowitz case. So I need to find out what happened there and catch up with that. I have got something. Oh, yeah, I will be doing a video sometime this week. From my perspective as a former professional dancer, in the Darren Henson, the NSYNC Bye 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 lawsuit against Sony, and I wanted to have a look basically at the history of suing for copyrighted or non-copyrighted dance moves. I know Fortnite has been sued multiple times. So I was gonna, and they are also, Epic Games are one of the parties being sued here as well for the Bye 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 dance. So I wanted to look at kind of why those previous lawsuits failed and why I think this one has actually got legs. And I wanted to do it from someone, from the perspective of someone who has myself been a professional dancer, but also loves intellectual property law. But I will be doing some stuff around what's going on here in the UK as well. I always avoid political stuff. I don't mind people sharing their political views. I respect any and all political reviews. Everyone has a right to them, and I have no problem hearing other people's views. I make a point of trying not to share mine, particularly. I just don't think it's over. There's never been a situation where I've needed to sort of talk about them. But we've had a couple of things go on in the UK recently. There was, I'm sure British people know what I'm talking about here, but there was 3 lads who on 2 separate occasions raped 2 girls. They were found guilty. They filmed the rapes, filmed themselves laughing at the young girls. And they were sentenced. They were found guilty, and they were sentenced to not a single day in prison because they criminalised them. And there's been outrage over that. And then on top of that, there was a young lad, Henry Nowak, who was stabbed, and his attacker called the police, falsely accused him of racism, and Henry Nowak was put in handcuffs. The police, denied that he had been stabbed. When he said, "I've been stabbed," the police laughed and said, "No, you haven't." And this poor man died in police handcuffs, saying, "I can't breathe." So there has been, I think it's an understatement to say, there has been utter outrage about that in the UK and ever anymore, because this is my home, and these things affect, they affect us as a society. Next week as well, again, no political allegiance or anything, but it's an important pivotal point. There will be the Rupert Lowe grooming gangs report, into the systemic exploitation of young girls, which I think is incredibly important. Cross-party support for that to a point, because the government isn't doing anything. And these are things I do need to, even if I just do a one-off video to comment on them, to acknowledge them, I think it's incredibly important. And these are things that, like, especially with the grooming gangs, these are things that affect, affecting Britain quite significantly at the moment. So I will still be keeping politics out of it as much as possible. But I welcome opinions from anyone with all sides of the spectrum. It is something now I do have to talk about, because Britain is in such a mess at the moment. And I am a UK lawyer first and foremost. So whilst there's a bit of calm from the settlement of Lively v Wayfarer, I'm just going to do little segments on these videos. You're free to watch them. You don't have to, by all means, but yeah, it's just something that will be coming very, very soon. All right, guys, thanks for watching.